Well, hello, my name is John Watts, and today we're going to discuss some issues about defending yourself in a debt collection lawsuit. We have a lot of videos about what are your 5 options, and then sort of broader speaking than that, we have a 5-step process to go through if you've been sued by a debt collector. But one of those options is to represent yourself. And so I was speaking with a client recently who was sued both in a lower type court and a higher type court, and he was saying, well, can I defend myself? Like, well, kind of depends. And then we talked about even the option of settling. And so we're going to talk about, can you represent yourself in small claims court, in district court in Alabama, circuit court in Alabama, and then what about this thing on summary judgment? Because we often hear people say, the debt collector trying to do summary judgment, and I just don't believe in that. I want my day in court. We'll talk about that. And then the final thing will be, if you settle, what are some things to think about if you're doing this on your own without a lawyer? So first of all, just real quick summary, 5 options. You can fight it on your own, settle it on your own. You can hire a lawyer to fight it, hire a lawyer to settle it, or occasionally bankruptcy is an option. But let's focus on that first one, fighting it on your own. In small claims court, that is very doable. Okay? There's an old expression, if you represent yourself, you have a fool for a client. A lot of ways that's true. That's true for lawyers. If we represent ourselves, it tends to not work out very well because you need that perspective. But I will tell you this, in small claims court, that's doable. It's really set up so that you don't have to have a lawyer. Now, it's fine to have a lawyer, but you don't have to have a lawyer. The thing you have to think about is, you say, okay, I'm not going to spend any money on a lawyer. That's fine. You don't have to in small claims. But you do have to spend something, and that is time. So we get people that I'll have a phone consultation with them, and they'll say, well, how much do you cost? And I tell them what our fee is for their particular case. They go, oh, I'll never pay that much. That's fine. They'll say, well, I want to do it on my own. That's fine. Here's what you need to do. And then they go, well, no. I'm not going to actually put any work into this. I want to represent myself, go into court by myself, defend myself in court, and make no effort. Now, they don't literally say all those words, but that's what they're saying. If that's your mindset, you're not going to like the rest of this video. And I don't think you'll like any of my videos because I'm very consistent on you either spend money or you spend time. There's no other choice. I either do my own taxes or I hire a CPA. I fix my own car, which that would never happen, or I hire a mechanic to fix it. Let's see, yesterday I went and picked up my car from Body Shop. It was in a rear ender. And, they fixed the bumper and the trunk and all that. It looks great now. Okay, I paid them money. Now what I can't do is say, well, I don't want to pay you money, Body Shop, and I don't want to get out there and sand and buy replacement parts and paint. I just want it to look right. Well, see, that doesn't work. Spend money or you spend time. In small claims, you have that option. You can spend time. And we have other videos that talk about that. We have some resources we can share with you about it. But if your attitude is, I don't want to spend any time doing this, well then I can almost guarantee you will be unsuccessful. And you will be calling my office saying, I got this judgment. What do I do now? They're trying to garnish my weight. Well, yeah, that happens. So spend money or spend time. But small claims, doable. What about district court? And let me show you this. So here's 0. Up to about 3,000 is small claims. You got to bring in small claims. From 3 to 10, you can bring it in district court or circuit court. Okay? So district court, usually the same judge, that's a small claims judge. Again, you can do it on your own. You need to spend time. Now I guess the warning I would say is understand that in small claims you're talking about maximum of $3,000. District court may be $9,000. So that's 3 times as valuable a case from the collector's standpoint. So if you go into it saying, well, they're going to treat it exactly the same as small claims, maybe, maybe not. Maybe since it's, typical small claims case is really more like $1,000. This is $9,000 or $7,000 or $5,000. You have to be prepared that they might be a little bit more diligent about proving their case. Now, it doesn't mean you can't do it on your own. You certainly can, but you want to put in the work. Figure out what you need to do to represent yourself. Now, what about circuit court? See, circuit court is definitely $10,000 and above, but it can also be $3,000 and above as circuit court. Here's the danger in circuit court. For most people, it's not very smart to do it on your own in circuit court. We have discovery, things called interrogatories, requests for production, requests for admission, depositions. If you're representing yourself, you have to be prepared to deal with all that. So they send you these questions, interrogatories you have to answer. Think of it as an interrogation. You got to answer those. Answer them the right way. Requests for production, where they say, give me a bunch of documents. You got to give them the documents that are appropriate. The most dangerous one is request for admissions. I can't tell you how many people say, I'm going to represent myself. I don't want to spend money on a lawyer. That's fine. But I'm going to represent myself. They get these requests for admissions. Like, these don't make sense. I'm going to ignore these. Well, you can do that. But if you ignore them, in 30 days, you just admitted those requests for admissions. And the big battle in these cases is, does the debt collector, does the debt buyer, Midland Funding, Portfolio, LVNV, Asset Acceptance, Unifund, all these different companies, does that company own your debt? See, they can prove, let's assume, that you took out a Capital One card, a GE Money Bank, a Best Buy card, whatever it is, and you didn't make all the payments. They can prove you owe the debt. So what? They have to prove that they own it. Well, those requests for admission, shockingly, or maybe not so shockingly, will say, admit that the plaintiff purchased your debt. Well, see, if you get that and you go, I want my day in court. I don't want to answer the stuff, you throw it away. You just admitted it. And then they come in, and this is what we'll talk about next, is summary judgment. They come in and say, Judge, see, there's no reason to have a trial. He admitted, she admitted that we own the debt. And then you go, no, that's not fair. Well, here's the deal. If you represent yourself, you're acting as your own lawyer. And I've heard judges say this in federal court, state court. They say, ma'am, if you're acting as your own attorney, you are an attorney. You are expected to know what an attorney knows. Small claims district court, that's pretty doable. Circuit court, very, very difficult to do. The other part of circuit court is that thing called summary judgment. And that's where they go to the judge and they say, look, Judge, no reason to have a trial. There's just no reason at all. There's only one outcome, and that is we, the debt collector, win. And they say, look at the law, we win. Look at the facts, we win. That's usually where they then come up and say, we served discovery and you admitted everything. Or you didn't even answer it and you admitted everything. And so, see, Judge, if the defendant, we'll call her Susie admits that she owes the debt, admits that we own it, well, then we don't need to have a trial. And then they'll put stuff in there about statute of limitations and whatever your defenses are. So if you ignore that discovery or you don't answer it the right way, you don't make the right objections, you don't answer it timely, you don't give the right documents, then they say, see, all that's been established. And so that summary judgment comes along, and then you get this big package of paper in the mail. You're like, what is all this stuff? You know, it's affidavits and documents and this and that. And so many people go, this is garbage. I read on the internet this is not valid. And they just throw it away. And maybe they write down on page 7 and flipping through there, it says, oh, by the way, this is set for hearing. Usually that's your only notice of the hearing. So if you don't notice it, you lose because you don't show up. if you do notice it, you write it down and say, well, I'm going to go to the judge. I'm going to argue to the judge. You get to the court, you haven't filed a response, and the time limit, very strict time limits to answering this. And the judge says, all right, we're here for the summary judgment. Well, I don't see a response by Susie. And Susie goes, but wait, I'm here. I want to argue it. Some judges might let you do it, but the rule says no. And most judges will say, I'm sorry, Susie. You should have responded in time. There's nothing you have to say here. Summary judgment in favor of the debt collector, you lose. You go, well, what does that mean? It means they can garnish your wages, garnish your bank account, sell your property, put liens on your property. It's a victory for them. A judgment is a judgment. So if you answer the lawsuit, do it on your own, you avoid a default judgment. That's great. So many people fail at that. But then you come along to the summary judgment. If you don't respond to that properly, you lose. And that is a judgment, and the case is over. And people go, that's so unfair. I want my day in court to argue what, I really don't owe this debt, or this Midland Funding, LVME, they didn't buy it. It doesn't matter. Because if you don't respond, you lose. That is your day in court. That summary judgment is your day in court. So I'm not trying to tell you, don't do it on your own. I talk a lot of people into not hiring me and doing stuff on their own. I'm telling you, in circuit court, very, very difficult. District court, small claims court, you can do it if you're willing to put in the time. And on all these cases, when people say, I know you wanted me to read this, I know you wanted me to go to court, I know you wanted me to watch this, I know you wanted me, but I was too busy, John. Okay, hey, I don't represent you. It's your choice. But if you say to yourself, I'm too busy to do the work, then either take your chances or spend the money. See, I'm too busy to do my taxes. Okay. Well, then I need to get my accountant to do it. If I say, I'm not going to spend money on an accountant, I'm not going to file my taxes, that might be a problem. Was there April 15 or something? That can be a bit of a problem if I don't file a tax return. And I can't really say to the IRS, yeah, hey, look, I didn't want to spend the money on an accountant, and I was too busy. I mean, I got Little League, and I got church, and I got a family, and I got this. I just don't have time to do my taxes. I don't think that flies with the IRS. It's not going to fly with the judge either. So the last thing I want to talk about is, let's say instead of fighting it, you go, I want to settle with the debt collector. Okay. I think for most people, settling with the debt collector is a mistake. But if you've looked at it and you say, I know this is what I want to do, I want to settle, that's fine. Here's the danger points. Do you actually have a settlement? Is it in writing? What do they do with your credit report? What do they do with taxes? Okay. So do you even have a settlement? We see people that they get sued, let's say for $5,000, and they talk to a collection lawyer, somebody really a collector in the lawyer's office, and say, look, all I can pay is $2,500. They go, okay, pay $2,500. Tell you what, we'll make it easy. Pay $3,000. So they send a check for $3,000. That should be the end of it, right? That lawsuit should go away. I've seen the collection firms then go get a default judgment for $2,000. They say, well, we got a payment of $3,000, but you owed $5,000. So we want a judgment for $2,000. So we can garnish your bank account, garnish your wages, sell your property, sell your house, sell your car, all that type of stuff. You go, wait, we had a settlement. They go, really? Where is it in writing? Because our notes say you just made a voluntary payment of $3,000. You got to make sure it's in writing. I had somebody, I don't know if they're telling me the truth or not. They were dealing with one of the major collection law firms. And I know all the collection law firms. And they said, I want to settle this case. So we'll use our example. $3,000, settle a $5,000 case. And they said, send me something in writing. And supposedly, it's hard to believe, but supposedly the collection law firm said, no, we're not allowed to do that. Our client doesn't allow us to put it in writing. Well, when the person told me this, I said, look, either you have somebody that doesn't know what they're doing at the collection firm, somebody's lying to you, from the collection firm, or you are dealing with a very unscrupulous plaintiff, the debt collector here, because nobody would refuse to put in writing. At every settlement you put in writing. Okay, it might just be an email, but it's in writing. So if somebody says, "Oh, we're not allowed to put this in writing," you're about to get taken advantage of. You run from that situation, because no lawyer that I know of, at least that I think is worth anything, would do that. So before you hand over money, you want them to hand over to you something in writing saying, if you pay this money, the case is over, it's dismissed with prejudice. If you don't get that, then you're just taking a chance paying money. Because if they won't put it in writing, do you think they're going to tell the truth when they get that $2,000 judgment against you? Remember, you owed $5,000 according to them. You paid $3,000. They go get a $2,000 judgment. And you say, but we had a deal. Do you think they're going to go, oh yeah, that's right. We were just trying to steal your money, but since you caught us, well, no. So if they won't put it in writing, if it was me, I wouldn't do it. Well, what about credit reporting? What happens with that? Are they going to fix your credit reporting? Are they going to delete it? What are they doing? Ask them about that. What about taxes? See, if you owe $5,000 according to the debt collector and you pay $3,000, they may issue a 1099 for $2,000. That's $2,000 of income to you. Are they going to do that? Or are they not going to do that? And what happens to the case? You see, you pay the money. Do they dismiss the case with prejudice? I've seen them do this sometimes, they want to dismiss it without prejudice. And I've had conversations with collection lawyers about that. They say, John, we want to dismiss it without prejudice. I go, why? They go, oh, well, that's just our policy. No, why do you want to do it? Because without prejudice means you can sue the client again. Well, we would never sue you again if you settle with us. We just want our options. Well, your options to do what? The only option is to sue. And I've had that conversation with lawyers, even in front of a judge, like, explain to me what the option is. Well, I don't know. I just want my options. No. If I settle, dismissed with prejudice, it goes away. Okay? And so if a lawyer's saying, no, we're going to dismiss it without prejudice after you pay, again, I'd run on that, because that is complete garbage. Okay? So what are they going to do? Well, what if you're paying them over time? See, sometimes they'll say, oh, yeah, we'll do this settlement over time, no problem. We just need to send you this little form. You just fill it out. It's no problem. Judge will take care of us. You get the form. It says consent judgment. What does that mean? Consent means you agree to it. Judgment means you lose. So this little paper, oh, it's no problem. We'll just send you this little paper. You just fill it out. Judge take. Yeah, that is a judgment against you if you sign it. You need to know that before you settle. And sometimes they'll say, oh, we have to do it this way. Really? Do you have to do it that way? I used to get that. We just tell the lawyer, we're not doing it that way. They go, oh, okay, well, we can do it the other way. Well, of course, there's another way. Most judges will let you make payments over time, and then they get rid of the case. But even if the judge won't let you do it, you got to know what you're getting into. And that's really the moral of this whole last part of the video on settlement is know exactly what you're getting. No surprises. And if somebody says, well, I can't put that in writing, but you just trust me. Well, I'm not sure that you should be trusting a lawyer who's not your lawyer. That lawyer, their obligation is to that person that sued you. Not to you, to the person that sued you. And so the lawsuit comes along and here you come and you go, well, are you going to get rid of the case? Oh, yeah, trust me. Yeah, I'll trust you in writing. Every time we sue a debt collector in federal court, they make promises when we settle. I always tell my client, you know what? I fully expect that they will do this. So we trust them, but we verify. There's nothing wrong with that. So you say to a lawyer, well, I absolutely trust you. I just need to verify that in writing. If they won't do it, you run. Now, the good collection lawyers I know of, that is not a problem. But I'm not going to tell you that there's no chance that you're going to get a bad lawyer who will try to trick you on this. And we've had to sue these debt collectors before, because they'll tell our client, oh yeah, you're settled, and then they go sue them. Debt collectors are infamous for doing this. I've got a case probably Tuesday I'm filing against a very major debt collector for this exact thing. You know, actually this one was the creditor said, $1,000, pay us $500, you're settled, we pay the $500, and then a debt collector gets it, says, I want $500. We go, here's the letter saying $1,000 debt, I'm good for $500. Here's my check, my money order, and they took it. And the debt collector says, well, look, all I know is you got to pay me $500. See, that's their attitude a lot of times. And sometimes if they have a lawyer who's not a good lawyer collecting for them, they can kind of intimidate that lawyer to try to overreach and get money they're not entitled to. So just protect yourself, okay? Whether it's right or wrong, protect yourself. If you're driving down the interstate, there's a big truck next to you and you're in their blind spot, they're not supposed to pull over on you. It's not much consolation when you're in the hospital. Protect yourself. What do we call it? Defensive driving. You got to protect yourself. If you're acting as your own lawyer, settling a case, protect yourself. Know what you're getting into. Do it the right way. Well, look, I hope that this little video has been helpful to you. If you have been sued in Alabama and you want to handle it on your own, just educate yourself, get the knowledge, and then take action. If you want to talk with us about what are your 5 options, or even more broadly speaking, what is our 5-part process? We have 5 steps to really figure out, well, what is the best option for you? Happy to help you with that. Give us a call, 205-879-2447, or you can go to alabamaconsumer.com. We have a ton of videos, articles there. You can watch the videos, read the articles, long videos like this. We usually have them transcribed. And so we put all that out there so that you can know what your rights are, and then to encourage you to take action. Maybe that's hiring us. Maybe we'll tell you, do it on your own. A lot of people we do. It just depends on what your situation is. So if we can help you in any way, let us know. And thanks for watching. Hope you have a great day. Thanks.